on Justice Scalia's legacy, the Supreme Court nomination process, as well as now, hot off the press, President Obama just nominated Judge Merrick Garland of the D.C. Circuit Court of Appeals to the U.S. Supreme Court. Before continuing, I want to extend a huge thank you to the student chapter of American Constitution Society, as well as the Aoki Center for the Critical Study of Race and Nation for co-hosting this event. Many members of our faculty could have joined us today. As it is, we already have quite a number of speakers speaking today. I'm grateful that Dean Johnson, Professor Alan Brownstein, Professor Al Lin, Professor Courtney Joslin, and Professor Carlton Larson are here today to talk to us about a number of issues that this nomination process has raised. Our goal is really twofold, and then have a conversation after hopefully achieving these goals. So the first is to have a discussion about Supreme Court Justice Scalia's legacy, his jurisprudence, and the impact that his thinking about constitutional interpretation has had on issues and cases that have gone before the Supreme Court. Currently, there are a number of important cases that will be decided by this court. It's unclear if the nomination of Judge Garland will go through. And so in which case, what might be the impact of Justice Scalia's legacy on these cases before the court? Now, second, we also want to talk about the nomination process itself and what the nomination of Judge Garland would look like. At the last minute, we want to thank Professor Lin, who had clerked for Judge Garland. That might have been a slip. To help us gain some understanding about Judge Garland's jurisprudence. So let me begin by just giving some very brief background on Justice Scalia. President Ronald Reagan nominated Justice Scalia to the Supreme Court in 1986. He had been a judge on the D.C. Circuit Court of Appeals, D.C. Circuit prior to his nomination. Before he died a month ago, he was the longest-serving member of the current Supreme Court, having served on the court for 30 years. Let's first talk about Justice Scalia's method of constitutional interpretation. He's known for promoting originalism, which is a method of interpreting the Constitution based on the idea that the meaning of certain words at the time that they were written is controlling, right? Meaning and definition of those words. What are your thoughts about Justice Scalia's originalist approach? And perhaps we'll start with Professor Larson.
Okay, sure. Certainly, Justice Scalia has been the noisiest proponent of originalism in American life over the last 30 or 40 years, particularly in his outside speeches and writings, where he has really been an apostle for the originalism movement, speaking to law students, to outside groups, as to why originalism is for him the preferred method of interpretation. It's not without flaws, but he always says it takes a theory to beat a theory, and originalism is better, in his view, than other theories. And yet, when you actually look at his work on the court, in a number of cases, of course, he does adopt an originalist approach. But I'd have to actually say that the truest originalist on the Supreme Court is actually Justice Thomas, in terms of really digging into historical sources in order to figure out what was the understanding of the Constitution when originally written. And interestingly, Justice Scalia sometimes just brushes that off. So, for example, in the McDonald case, where Justice Thomas wrote a very thoughtful opinion about the right to an individual right to a handgun under the Privileges and Immunities Clause of the 14th Amendment, promulgated in 1868, Justice Scalia essentially ignored that and actually sort of sneered at it in the oral argument, said it was the darling of the professoriate, of academic interest, but not really of judicial interest. And so, in terms of actual originalism on the court, I think he's been eclipsed by Justice Thomas, and I think he's also been frustrated in recent years because nobody else other than Justice Thomas really shares that methodology. So Justice Kennedy, for example, certainly is not an originalist other than making sort of very vague noises about federalism. And neither Chief Justice Roberts nor Justice Alito is either. Indeed, there was a very telling moment in a case from about 5 years ago about violent video games, in which Justice Alito said in the oral argument, "I think what Justice Scalia wants to know is what James Madison thought about violent video games." And that, of course, is a very telling question because the question itself is somewhat silly. Right? We wouldn't look to the 18th century to guide us on a question about violent video games. But yet, that in some ways is a mockery of, that question is a mockery of the entire originalist enterprise. And so I think Justice Scalia has been frustrated in his last years on the court by the failure of even his ostensibly conservative colleagues to fully embrace the theory that he worked so hard to promulgate. I do not know Judge Garland, but I do know he's not an originalist. And so with whoever the new nominee will be, who eventually sits on the court, it may not be Judge Garland, it may be a nominee of President Clinton or President Trump. In such a case, I would not expect a strong originalist either. Perhaps the President Ted Cruz would appoint an originalist. But my guess is going forward, the court will not be stridently originalist in a significant way. And so this will be a moment in constitutional or intellectual history, but it won't have enduring impact.
Professor Brownstein?
Thank you for organizing this, and thank you all for coming during the lunch hour. So I wanted to try to provide some additional perspective to discussions about Justice Scalia's jurisprudence. And if you listen to a lot of the commentators that summarized Justice Scalia's years on the court, they described him as an originalist and as a textualist. They acted as if those were essentially the same methodologies of constitutional interpretation. But they're not. A textualist focuses on what the Constitution actually says. The original meaning can't escape the parameters of what a constitutional provision states in writing. An originalist, as Justice Scalia employed the term, focuses on the original understanding of the text, even if that meaning bears very little resemblance, if any, to the actual language that's used in the Constitution. Under Justice Scalia's form of originalism, a court can essentially ignore what the text says based on a contested historical analysis, an analysis that suggests that the Constitution really doesn't mean what it says. Justice Scalia was perfectly willing to ignore the language of the Constitution's text in the service of his originalist methodology. And I'll give you an example. I was going to have it up on the PowerPoint, which I rarely use, but apparently that was difficult to do. But you all have your copy of the Constitution with you.
Probably on their app, on their phones.
Well, you shouldn't leave home without some more students. But the 11th Amendment says, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Now, it is indisputable that this text does not say anything to limit the judicial power to adjudicate cases brought by the citizens of one state against the citizens' own state government, citizens of another state, or citizens or subjects of any foreign state. It says nothing about suing your own state. And it's also indisputable that the text does not mention sovereign immunity or any other doctrine that shields a state government from claims brought against it by its own citizens. Yet Justice Scalia and other conservative justices on the court have interpreted the 11th Amendment to bar suits in federal court by a citizen of a state against the citizen's own state government. They've interpreted the 11th Amendment to read a non-enumerated state governmental right of sovereign immunity into the Constitution. And this rejection of the text was pretty forthright. The court stated in the Seminole Tribe case, it's a 1996 case, in an opinion in which Justice Scalia joined, the court said, we understand the 11th Amendment to stand not so much for what it says, but for the presupposition which it confirms. Originalism under this perspective does not mean fidelity to the text. Now, let me make a couple of other quick points about originalism. Justice Scalia argued that one critical virtue of originalism was that it prevented Supreme Court justices from interpreting the Constitution to further their own personal values and their own ideological agendas. Now, many of Justice Scalia's critics argued, and Professor Garland suggested, that sometimes Justice Scalia seemed to ignore history and originalism. And sometimes he seemed to do that when, if he paid attention to history and originalism, a case might come out in a way that he didn't prefer, in a way that was inconsistent with his own values and ideology. But let's put that issue aside for the moment. There are other reasons why originalism doesn't accomplish Justice Scalia's goal of limiting the court's ability to incorporate its own ideology and personal values in its decisions. And one reason is that in many cases, the historical understanding is seriously contested. So, for example, with regard to the 11th Amendment that I just read to you, many scholars directly challenged the account of the 11th Amendment that I just described to you on historical and originalist grounds. Yale professor Akil Amar, for example, wrote that the court's interpretation of the 11th Amendment, and I'm quoting here, misinterpreted the Constitution's text, warped its unifying structure, and betrayed the intellectual history of the American Revolution that gave it birth. That's not a living Constitution argument. That's an argument that says the court got the history wrong. And the problem here is that Supreme Court justices are not trained historians, but they're adopting an interpretive methodology that requires an accurate understanding of history. And under these conditions, where non-historians try to reach historical conclusions, it's hardly surprising that the justices either innocently or deliberately read history through an ideological lens. And so it's inevitable that personal values and ideology continues to determine the court's reasoning and holdings. But this is accomplished through the screen of an originalist analysis. And there's one more reason why originalism doesn't really cabin judicial discretion and value judgments. And that is the court's application of the law in a given case depends on the justice's understanding of social reality. And a justice's understanding of social reality necessarily depends on his or her background and values and ideological predispositions. And I'll discuss this more when I talk about Justice Scalia's position on church-state issues. But the key point here should be relatively obvious. Courts can't avoid the responsibility of construing the world to which law is applied. And that construction of social reality is intrinsically value-based. So even under an originalist perspective, there are more than sufficient opportunities for courts to be influenced by their values and their ideology.
Thank you. Well, why don't we turn to more specific issues and cases that went before the court, just to gain a deeper understanding of the impact that Justice Scalia had on various issues. So to start us, there are many cases that have gone before the court while he was alive, and certainly today, this term. So questions about race and women's right to have an abortion, issues regarding religion, gun ownership. Many of these issues have arisen. Professor Joslin, could you start us off by talking about what you thought might be the most, his primary influence in the areas in which you study and research?
Sure. So as we have just heard, Justice Scalia subscribed to an originalist theory of constitutional interpretation. And I think it goes without saying that this theory does not bode well for women or for lesbian, gay, bisexual, and transgender people. We have a long history of discrimination against women and LGBT people in this country. Just to name off a few, women, when they married, lost their legal identity. Their legal identity merged into that of their husband. They could not sue or be sued in their own name. They had no control of their own earnings. With regard to LGBT people, just to give one example, in 1953, President Eisenhower issued an executive order requiring the dismissal of all openly lesbian and gay, or all lesbian and gay employees from federal employment. And against this historical backdrop, it's not particularly surprising that Justice Scalia took the position that laws that discriminated against women and against LGBT people did not violate the Constitution. Justice Scalia took the position that nothing more than rational basis review should be applied to laws that classified on the basis of gender or sexual orientation. With regard to the Due Process Clause, he took the position that laws that limited marriage to the union of one man and one woman did not violate any fundamental rights. With regard to a woman's right to terminate a pregnancy, he also held that laws that restricted that right did not violate the Due Process Clause. So to be clear, his constitutional rulings generally have not been favorable to women or to LGBT people, but maybe what is even more noteworthy than the conclusions in those cases was the disparaging rhetoric that he used in his constitutional opinions, particularly with regard to LGBT people. So take Romer versus Evans, for example. Romer was a constitutional challenge to a state constitutional amendment that prohibited the state or any localities from protecting lesbian, gay, or bisexual people. The court, in an opinion written by Justice Kennedy, struck down the state constitutional amendment as unconstitutional. Justice Scalia dissented, but he did not stop by just concluding that the amendment was constitutional. He went on to describe Amendment 2's objectives as unimpeachable. The only type of animus expressed by the Colorado Amendment, he said, was the perfectly permissible kind that condemns certain conduct as reprehensible. And Justice Scalia suggested that the type of animus against LGBT people was similar to the animus harbored against murder. 7 years later, in Lawrence versus Texas, the court struck down a Texas statute that criminalized same-sex sexual intimacy. This type of law, Justice Scalia suggested, was not only constitutional, it was an appropriate means of expressing the people's belief that same-sex sexual conduct was immoral and unacceptable. Many Americans, Justice Scalia continued, do not want persons who openly engage in homosexual conduct as partners in their businesses, as scoutmasters for their children, as teachers in their children's schools. This, Justice Scalia said, was not discrimination, it was mainstream. So again, I think it goes without saying that Justice Scalia certainly will not be remembered as a champion of women's rights or but I did want to say before I close that some of his opinions, I think unintentionally, have served as building blocks for LGBT and women's rights. And I'll just use one example. It's a statutory decision, not a constitutional decision. The case is called On-Call versus Sundowner Offshore Services, and it was a case brought under Title VII, the Federal Employment Non-Discrimination Statute. It was brought by a man who was sexually harassed by other men, and he alleged that he was subjected to unlawful sex discrimination under Title VII. And the district court and the Court of Appeal had held that a man has no cause of action under Title VII for harassment by male coworkers as a matter of law. And this conclusion was one that was followed by many lower courts at the time and was an enormous barrier to harassment cases brought by LGBT employees. And in his opinion for the court, Justice Scalia reversed, and Justice Scalia noted that male-on-male sexual harassment in the workplace was assuredly not the principal evil Congress was concerned with when it enacted Title VII. But he went on to state, statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils. And although the plaintiff in the case did not identify as a gay man, the decision opened the door for many lesbians and gay men to bring claims of sex discrimination under Title VII. And the EEOC has actually recently taken the position now that all discrimination against lesbian, gay, bisexual, and transgender people is a form of sex discrimination prohibited by Title VII. And this conclusion could not have been reached had UNCAL gone the other way. So I'll close on that more positive.
Dean Johnson, you had written an op-ed about Justice Scalia's impact on race-related issues before the court, and in fact, we have Fisher versus University of Texas is before the court this term. Can you talk about your op-ed and how the legacy on race, discrimination, and equal protection issues might relate to Fisher versus Texas?
Sure, happy to do so, and thanks, Professor Villazor, for putting this panel together, and thanks for the panelists for allowing me to sit with you. I'll try to offer something here. I think actually where Justice Scalia's civil rights impact will most likely be felt is in a place that some people might not think it will be felt. And I'll talk about the criminal justice part in a minute. But I think his willingness to allow rights to be waived through contract, through arbitration clauses, through waiver of various rights will have an impact on consumer claims and civil rights claims. I think his willingness and efforts over many years to narrow civil rights class actions under Federal Rule of Civil Procedure 23 will have long-term impacts, and actually have already had impacts as we've seen a narrowing of the class action device in pursuit of Title VII claims. The point that I think that Professor Villazor was trying to direct me to is sort of the criminal justice impacts of some of Justice Scalia's jurisprudence. And I want to give credit today to Justice Scalia for helping create the Black Lives Matter movement. And I think some of this can be drawn from a decision of his in 1996, Wren versus United States, in which the Supreme Court, in a unanimous opinion by Justice Scalia, held that a traffic stop that was in fact based on race, but was also, there was probable cause for a traffic violation, could be consistent with the Fourth Amendment. In other words, there was no Fourth Amendment violation even though the police actually stopped the drivers of the vehicle because they were black. And in a footnote, not in a footnote, but buried in the text was a one-liner saying that if there was a racial claim of racial discrimination, it could be brought under the Equal Protection Clause of the 14th Amendment. What did that decision mean? It meant that police officers, if they could concoct some kind of reason for a traffic stop, could rely on that reason for purposes of the Fourth Amendment, even though if the traffic stop was in fact based on race and they wanted to check on these drivers in part because they were black or they were Latino or some other background that they found to be suspicious. What that has contributed to, I don't want to say it started, but it contributed to a situation where many communities, African Americans, Latinos, and others felt that they were being racially profiled by the police, and in fact were, in certain circumstances, being racially profiled by the police. Now, Justice Scalia in the Grand case said that the Equal Protection Clause could be a possible remedy for claims of racial discrimination. The problem is that under the Equal Protection Clause as interpreted by the Supreme Court in a case called Washington versus Davis, you have to establish a discriminatory intent to prevail on an equal protection claim. And it's notoriously difficult to prevail on such a claim. Establishing a discriminatory intent by police officers when they're going to say we were just trying to ensure the safety of the public is very difficult to prove. And there's a number of cases where the Supreme Court itself has rejected very strong evidence of discriminatory intent. For example, when almost all crack cocaine prosecutions were directed at African Americans in one particular district. So you think if an equal protection claim can't be shown there, how can it be shown in an ordinary driving while black stop? To me, that's a decision that probably hasn't gotten the attention that it deserves. It has from people like Professor Joe and Professor Chin who've written about it, but it's one that I think has deeply impacted policing across the United States, and it's one that's likely to have an impact on the future. But I will end there.
Do the other panelists want to talk some more about Justice Scalia's legacy and other issues?
tell you what I really wanted to talk about.
Okay, go ahead.
One of the things that interests me about Justice Scalia's legacy, and this is actually I think a positive contribution, he really focused much on the language of statutes and their interpretation, whether it's the Federal Rules of Evidence, the Federal Rules of Civil Procedure, or the Immigration and Nationality Act. You might not like the way he interpreted the statutes, but he really was rigorous in his attention to the statutes in a way that some other justices weren't. He was a little extreme in some people's view. He wouldn't consider things like legislative history in the interpretation of statute. He was very much against the interpretation of international law or any other sort of non-textual sources for interpretation of statutes. I'm not saying he's 100% consistent with that principle, but he was really generally very consistent with looking at the statutes. He was also particularly consistent, and the reason I focus on these two issues is because they come up so often in immigration cases, looking at the statute, but he also was consistent in his deference to administrative agencies and his willingness to defer to decisions on agencies in interpreting reasonable interpretations of statutes, for example, as well as factual decisions. So in immigration law, I would not classify Justice Scalia as necessarily anti-immigrant or pro-immigrant. It really depended on the particular statutory language he's interpreting, how that played out in terms of whether there should be deference or not. And so you see some decisions, like one of his early concurring opinions in a case called Cardozo-Fonseca versus INS, where he agreed with sort of a generous interpretation of the asylum statute. And he based it on the text of the statute, and he said you shouldn't defer to the agency because the text of the statute is very clear. Another case, very different case, he very narrowly interpreted the asylum statute in terms of the linkage between persecution and a person's political opinion. He said this language in the statute, on account of political opinion, means that there has to be a direct link. And so he was, in one case, he was pretty pro-immigrant. The other case, he was less so. But in immigration, I think he's really all over the board. And actually, before I forget, I should commend to you a blog post by UC Davis Law student Sadie Weller, who sort of analyzes his immigration jurisprudence for his entire time in the court. I learned a lot from that.
Let me say a little bit about Justice Scalia's church-state jurisprudence. I think it's clear that as a general matter, Justice Scalia believed that the religion clauses of the First Amendment, that is, the Free Exercise Clause and the Establishment Clause, they should be interpreted to mean as little as possible. In his view, most church-state issues should be decided by political deliberation rather than by constitutional adjudication. I think Justice Scalia's position on church-state issues jeopardized our constitutional commitment to religious liberty and religious equality. Justice Scalia seemed to trust the government's involvement with religion. I don't. He seemed to trust the majority's decisions as to the proper relationship between government and religion. I don't. I think that without serious, meaningful constitutional checks on government and the majority, government will interfere with religion too much and abridge free exercise rights, and it will promote religion too much and end up undermining religious equality. Now, I think Justice Scalia's position on the Establishment Clause is generally well known. People recognize that he had very little sympathy with Establishment Clause constraints on government promotions of religion. What people may forget is that Justice Scalia authored the majority opinion in Employment Division versus Smith in 1990. And that was the case that gutted the Free Exercise Clause and rendered it virtually totally useless as a means for connecting minority religion practices against government interference and abridgments. Now, I want to focus on just one aspect of Justice Scalia's jurisprudence here, his Establishment Clause jurisprudence. This relates to the argument I made about justices having a lot of discretion in interpreting social reality, the world that exists to which laws apply. So Justice Scalia believed that government could favor monotheistic faiths in its pronouncements, displays, and public prayers. He basically thought atheists or people who subscribe to non-monotheistic religions could be treated as outsiders by the government. The government could act as if their beliefs were unworthy of recognition or acknowledgement. But Justice Scalia stated repeatedly in his opinions that government could not discriminate among monotheistic faiths. He said government couldn't endorse sectarian messages that specified details, and I'm quoting here, upon which men and women who believe in a benevolent, omnipotent creator and ruler of the world are known to differ. For example, the divinity of Christ. And Justice Scalia also asserted, and he joined opinions that argued, that government could not coerce religious observance or religious exercise. Justice Scalia believed that government could endorse religion, but it could not coerce religion. Now, I think this limited interpretation of the Establishment Clause is too narrow. I think the Establishment Clause prohibits more than coercion and more than discrimination among monotheistic faiths. But the key point here is the way Justice Scalia's understanding of social reality influenced his application of these principles. So Justice Scalia said government can't coerce religious exercise and observance, but he never found any government practices to be unconstitutionally coercive. So, for example, he didn't think a graduating senior was coerced when the student was directed to stand while prayer was recited at her graduation ceremony. And Justice Scalia didn't believe that the residents of a town were coerced when they were directed to stand, bow their heads, and join in reciting a sectarian prayer before the beginning of a town board meeting, when they were attending the meeting to address the board, to try to influence its decisions on public matters. And similarly, Justice Scalia never found any government display or state-sponsored prayer to unconstitutionally discriminate among monotheistic faiths. So monuments displaying a Protestant version of the Ten Commandments didn't discriminate against Catholics or Jews. A standalone creche in the county courthouse didn't discriminate in favor of Christians. Guest chaplains offering prayers for the audience in Christ's name before the beginning of a town board meeting weren't impermissibly discriminatory. So the fact that Justice Scalia recognized that from an originalist perspective, discrimination among monotheistic faiths was impermissible, that didn't do religious minorities any good in the cases that came before the court, because Justice Scalia could never bring himself to acknowledge that any religious message was ever sufficiently sectarian or sufficiently discriminatory to warrant judicial intervention.
Let me just say a little bit about Justice Scalia as a writer. There's really nobody like Justice Scalia in the history of the entire court as a writer. You can go through con law and then you start reading Scalia opinions, and even if you disagree with them, there's something about how they read that is just incredibly engaging. I confess I'm one of many people who, when a new Supreme Court decision comes out, if there's a Scalia dissent, I will typically read the Scalia dissent first, because I know that's where all the juicy bits will be, and it will help me understand what's going on in the majority. One of his absolutely best pieces of writing I would commend to you is his 2004 dissent in the Hamdi case, where he found, using originalist methods, that the United States military had no authority to hold a United States citizen suspected of involvement with foreign terrorist groups under military authority. And it's a ringing endorsement of the value of jury trial and the rule of law. And I think it's probably easily in the top 10 greatest judicial decisions ever written. He didn't write a lot of majority opinions. the memorable writing tends to come from the dissents. And part of the reason is that neither Chief Justice Rehnquist nor Chief Justice Roberts was super confident about Scalia holding 5 votes, that he would tend to write things that would perhaps drive O'Connor or drive Justice Kennedy away. So he didn't write too many majority opinions that significantly changed the law. The one that has been the most significant, I think, is the Heller case, where by 5-4 vote, Justice Scalia, writing for the court, found that the Second Amendment protected the right of an individual to a handgun within the home for purposes of self-defense. And this has been labeled by many people as a triumph of originalism, not just because Scalia wrote the opinion in originalist language, but because the dissent essentially also analyzed the issue on originalist terms. And so the view was that the entire frame of debate has been set by Justice Scalia. But I think in some ways that's overstated. And that is, first of all, if you actually look at the opinion as a whole, it actually doesn't make a whole lot of sense on originalist terms. There's the textual embarrassment about the language about the militia, which Justice Scalia more or less elides. But there's a further problem that he immediately grafts on various exceptions to the newly recognized right, which were that it doesn't apply to convicted felons, it doesn't apply to people who are mentally ill, it doesn't apply to sensitive places like schools and government buildings, and it doesn't apply to various commercial restrictions on the sale of firearms. Now, those are all certainly plausible policy restrictions one might have on firearm ownership, but it is simply impossible to find any 18th century source that describes the right at issue in those terms and with those exceptions. What you see is something that looks actually very late 20th century and very early 21st century, concern about violence and protecting your home against intruders. You don't see a lot of writing about this in the late 18th century. Firearms just weren't that good. They weren't that, nobody had a loaded firearm next to their bed ready to shoot an intruder the moment it happened. I mean, it just didn't work that way. So in many ways, Heller is an example of exactly the sort of living originalism that Justice Scalia claimed to deride. That is, historical sources are being used in a way that actually advances a current agenda. I'd also note that the dissent argued, I think, in originalist terms for a couple reasons. First of all, it thought that Justice Scalia had done quite a bad job, that the history simply didn't support this, and that a very strong originalist argument could be made on the other side of the issue. And secondly, because there simply wasn't much case law on the subject. In the absence of a lot of case law, what are you going to do? Well, you're probably going to look to the historical sources surrounding the provision. So the big question, of course, is, Heller being a 5-4 decision, what happens if a new justice replaces Scalia? Would this decision be reversed? Well, it's certainly possible. My guess is what we'd more likely see is a slow whittling down of Heller, such that Heller remains the decision on the books, but a variety of gun restrictions are nonetheless upheld. That seems to be the more likely course that these cases would take. And one might note that in the lower courts, pretty much all restrictions other than outright prohibitions are tending to get upheld with a few exceptions.
That's actually a great segue to the next question. As I noted, President Obama has nominated Judge Merrick Garland to the Supreme Court. Some information about Judge Garland. He clerked for Justice William Brennan. He had been serving as Chief Judge of the D.C. Circuit, and when he was confirmed in 1997, the vote was 76-23. So, Professor Al Lin had clerked for Judge Garland. Can you tell us a little bit more about his background and his jurisprudence?
Sure. So thank you for having me on this panel, and I apologize for my informal attire. The announcement this morning was as much a surprise to me as anyone else. So I think it's worth highlighting a couple things in his background to try to understand a little bit about Judge Garland and his jurisprudence and how he might work out as a Supreme Court justice if he were confirmed. He has an extensive background. He worked in the private sector. He worked for Arnold & Porter for a number of years, then became a federal prosecutor, leading the prosecution of the Unabomber, as well as the Oklahoma City federal building bombers. And then he's been on the DC Circuit for 19 years and is currently the chief judge. And so I think, at least from that last point, that he would have some of the same, share some commonalities with Chief Justice Roberts in terms of understanding the importance of the court as an institution and of the opinions of the court in maintaining the respect for the institution. In terms of his, his approach, his style, let me say a little bit about my experience clerking, because I think it reflects something about the thoroughness with which he approaches every case. So we had to prepare bench memos for him, and at least I, prepared my bench memos with a sense of fear and trembling. Not because he's a scary guy. He actually is a very pleasant person to work for, but because you were afraid that you would miss that one point, because he wanted you to go down every path, to explore every possibility, to look at every issue, and you knew that it was just impossible. Right? There was no way that you could do it, and he would always send you back to look up this thing which you should have figured out, but he figured out that you had it. But I think that speaks to how he prepares, and his manner on the bench is similarly thorough. He's a very active questioner, so that's maybe something he would share with Justice Scalia. But I think he asks the questions to gain information or to provide information that would be useful in resolving a case and writing the opinion. So he does that with these goals in mind, rather than out of some desire to show off his intellect. In terms of what his jurisprudence looks like and what it might look like if he did become a Supreme Court justice, I was looking back at one of the opinions that came out of the chambers back when I was clerking, and there's nothing particularly interesting about the case. It was a case involving a challenge to rules that were issued by the FAA regarding air tour operators in the Grand Canyon, and basically there's too much noise, too many helicopters buzzing over the canyon, and the FAA was basically told by Congress to kind of control the amount of noise which was disturbing the park experience. And so there was a challenge brought by both the operators of the air tours as well as by environmental groups. Neither side was satisfied by what the FAA was doing. And Judge Garland nicely captured the parties' arguments. As he put it, the operators essentially argue that the rule does too much too soon, whereas the environmentalists contended that the rule does too little too late. So I think this reflects his writing style. I mean, he's not like Justice Scalia in his flamboyancy, but he is a very clear writer. He gets to the issues. He's very thorough in addressing all the issues raised, and they're eminently readable opinions. But I don't think you'll see the sort of provocative language that you often see in Justice Scalia's writing. In that case, the court ultimately upheld the rule, not because it believed the rule is just right, as he wrote, but because it deferred to the agency's reasonable exercise of its judgment and technical expertise. And so I think that reflects his appreciation of the role of the courts, especially with respect to the other branches. They're respecting the role of the agencies to administer the laws according to congressional delegation, and that the courts do have a role to look carefully at what the agencies are doing to make sure that they are following the statute, but not to intrude upon what the agency's proper function is. On a broader but related note regarding, what would statutory interpretation look like under him, I think you're right, he is an originalist. He does look carefully at the statutory language, but his interpretation of the statutory text is not limited to kind of looking to the dictionary or to the plain text of the statute, but considering other factors, including trying to understand, well, what was Congress really trying to accomplish, and making sure that the statute is interpreted appropriately in light of that context. So he's not an ideologue, but he's a very careful judge, and he's a fair judge who thinks about carefully about all the things I think that you would want a Supreme Court justice to think about.
Thank you. I want to make sure that we have time for a Q&A. So let's open it up now for questions. Yes.
Sure. Thank you all for coming today. I was wondering, in light of kind of the political backlash and the ridiculousness that's going on in Congress right now about replacing Justice Scalia, I've heard some people talk about suggesting term limits for justices to make the nomination process a little bit more predictable. I was wondering if any of you had thoughts on that.
Just to clarify, so term limits on the justices.
Yeah, something like a 20-year term.
Yeah, so actually, I think this is a terrific idea. I mean, I think the best proposal I've seen would be that you have 18-year terms for the courts staggered every 2 years. If you do that, then each president would get 2 nominations, and you would eliminate the possibility of strategic retirements. Because I think that's one of the biggest obstacles we have right now is that justices wait to a particular point to retire so that the president that they want will then replace them. And that, played well, can sort of entrench a court for a long time. And so, given that the typical justice serves about 18 years anyway, given that there's a lot of reasons to be concerned about justices in their late 80s or early 90s, adjudicating significant cases for the rest of us, a system in which we had a more regular, stable, predictable, consistent appointment process would be a huge improvement over the mess we have now.
I think it would also allow presidents to appoint slightly older candidates instead of wanting to appoint the youngest person possible, because that would give you the longest period of time where you have an entrenched ideologue reflecting, your president's own values on the court. If the term was limited to 20 years, you could appoint someone with 55 years of experience, 50 years, as opposed to looking for someone right out of the cradle. As long as possible.
Yes, sir.
I'll preface this with the statement that if I'm asking a very naive question, I apologize. But my question has to do with hearing conservative, moderate, liberal judges, and just today learning about this originalist versus theorist. I kind of grew up with the notion of the Supreme Court being the Supreme Court, that politics or being liberal or moderate, now to find out whether being historical or not, was immaterial, if I dare say the word. That, I'm not trying to portray them as being perfect, but again, I would think that whether they're liberal or, because I heard this morning somebody say, if this guy gets, nominated and approved, we're gonna have a liberal Supreme Court. And to me, a clear layman, that means, oh great, they're gonna start saying we can have, whatever we want. Take liberalism to its broad edge. And that's why I preface with, about being naive, that I would think the Supreme Court would be free of that distinction or label or, anyways, I'll stop.
Professor Joslin, do you want to address that?
Okay, no, go ahead.
You go first.
Please, go ahead.
I guess what I would say in terms of Justice Scalia's opinions with regard to LGBT people, I'll speak to that specifically. He was adhering to his originalist perspective about the scope of the Equal Protection Clause and the Due Process Clause, but I think his rhetoric suggested his ideological perspective about lesbian and gay people and reflected what seems to be a belief that same-sex sexual conduct was immoral behavior. And And many people are of the opinion that many justices, their background, their perspective on life does influence their opinions.
Is that what we want? I mean, pardon me, do we want their person? I mean, again, I'm not asking to cast them into a particular mold, but again, I would have thought that the Supreme Court, that you would go in and say, I'm the justice for the people of the United States, and I'm going to listen to what's presented to me. And yes, my personal opinions, my religious beliefs, my political beliefs may influence, but I'm not here for that.
Many people might take the position that one cannot entirely divest oneself from one's own experience and perspectives in considering.
It's a hotly debated topic where there's a great, you can have whole conferences on that topic. I mean, Justice Thomas, when he was testifying in front of the senators, said that he was going to be stripped down like a runner and not bring any ideology to the Supreme Court. Most would say that he probably did bring a little bit of ideology to the presidential law. I mean, there's a question of degree, and I think most of us would say that Justice Scalia had some very strong views on a variety of issues that probably did influence his opinions. Maybe that's not the ideal, but it may be part of the reality.
Yeah, I think certainly, the ideal is, justice is blind, which it should be. And I think, for most legal issues, probably 99% of judges in 99% of the cases would agree on what the answer is. The problem is there are a handful of really, really, really hard cases. And those are the cases that get to the Supreme Court. And for much of the history, you see the court dividing. Sometimes it's 5-4 or 8-1, 7-2. Still a decent chunk are unanimous, but there are ones where people of extraordinary legal ability and training, who've thought this question through, had the briefing of the best attorneys out there, can still reach differing legal conclusions. And inevitably, some of that is perhaps informed by personal legal philosophy, which is not a direct result of politics or political views, but sometimes is correlated to that. And I do think all the judges are working their very best to apply the law as they see it, but in many cases determining what that law is quite hard.
We have room for one more question. Yes.
What do you think the odds are of confirmation of Garland or anyone who's nominated this year? What do you think is going to happen now?
Well, I don't work in Vegas. I have no particular insight into that, but I think Judge Garland has as good a chance as any other nominee. I mean, he is.
Zero.
Well, I mean, he's highly qualified, and it would be hard given the kind of record of pronouncements from Republicans in the past who basically acknowledged that he's highly qualified to step back from that. But we have politics as it is today.
Please join me in thanking our panelists.
I should talk just for a few minutes. I had a long meeting yesterday with all the deans.